come back like?
Could come back, say just before 12.
Okay.
Like 11:45.
Can you come back just before 12?
Thank you, Doug.
Okay.
Thank you.
Morning, everyone. We'll call our meeting to order. First item we have on the agenda is request for bill introductions. Are there any bill introductions? Seeing none, we'll move on to our hearing. We're having a hearing on HB 2079, transfer and duties concerning address confidentiality program, safe at home, from the Secretary of State to the Attorney General. We'll start out with an overview from the reviser, Jill Walters. Jill, are you on?
Excuse me, sir. Yes, I am here. Can you hear me now?
Yes, thank you. Welcome to committee.
Thank you so much, sir. What House Bill 2079 does is it transfers the duties concerning the address confidentiality program, also known as Safe at Home, and the registration for charitable organizations from the Secretary of State to the Attorney General. Currently in law, the program, the Safe at Home program, seeks to provide address confidentiality for victims of domestic violence, sexual assault, human trafficking, and stalking. And they can seek to obtain, the victims of these issues can seek to obtain a designated address to use as a substitute mailing address. So all the amendments really just change the reference from the Secretary of State to the Attorney General. One of note is in Section 18, that statute maintains current law, so the Secretary of State would still adopt rules and regs concerning voting procedures to maintain a confidential address, but all other provisions for the Safe at Home program requiring a confidential address would go to the Attorney General. In House Committee and Judiciary Committee, they amended into the bill the provisions of House Bill 2080, which transfers the duties concerning registration of charitable organizations from the Secretary of State to the AG. Under current law, under KSA 17-1761, a charitable organization in Kansas may not solicit funds or employ a professional fundraiser or professional solicitor to solicit funds unless they've registered and filed the reports under the Charitable Organization Act. So what this new part of the bill before you today would do is create the Charitable Organization Fee Fund, which would be administered by the AG and the money would be used to carry out the duties of the Act, of the Charitable Organization and Solicitations Act. There's a couple of things in the section that are really just boilerplate, transfers custody of legal records and other items to the AG. To note, it maintains current law regarding charitable organizations that are not required to register under the Act, so that those provisions do not change at all. The only changes in regard to the Charitable Organization and Solicitation Act is right now each charitable organization has to pay a $20 registration fee, and this would increase to $25. And then, as you can see in section 6 and 7, right now there is no fee on professional fundraisers or professional solicitors to raise funds. And under this, they would have a new fee. Both those folks would have a new fee of $25 when they registered to be able to solicit funds in Kansas. The bill would take effect upon publication in the statute book, which means July 1, and the bill passed the House 70-54 on February 3rd. And I'd be pleased to stand for questions, sir.
Thank you, Jill. Questions for Jill? Seeing none, we'll move on to proponents. First proponent we have is the Attorney General, Derek Schmidt. Welcome to committee, Derek.
Thank you, Mr. Chairman, and thanks for having us in. This bill has two parts. If it's okay with you, I'm going to talk about the charities piece and then ask Michelle McCormick, the head of our Victim Services Division, to say a word about the Safe at Home provision. The big picture here is when Secretary Schwab started serving, he and I sat down and sort of compared notes on several areas where there's interaction between the responsibilities of the Attorney General and those of the Secretary of State, and said, are there things we can do differently while we're serving together that would be more efficient? These two programs are two that we identified. Scott and I thought there was a more efficient way to run them both, and that's why we're here with this bill. On the charities piece, let me just start with the bottom line. This doesn't change the law on what a charity or a fundraiser has to do in Kansas or who has to do it. This is not a substantive change to any private party's obligations. I'll talk about the fees in a minute because we really got hung up on that in the House discussion. It is somewhat confusing. But in terms of who has to register, doesn't register, what they're required to do, not do, this doesn't change any of that. This takes a program that is very small, it's been on the books for a long time, the Charities Registration Program, that it's like a $100,000 a year program in round numbers. It's not a big program. But under current law, as it's been for many years, its administration is divided between two offices. I run part of it, and the Secretary of State runs part of it. And we just don't think that's a very efficient model. Put it all in one agency or another, and we agreed to take it. Here's the way the current architecture works. So if you are an entity that's required to register, either as a charitable organization or a professional fundraiser, professional solicitor, you go to the Secretary of State's office, you pay the requisite fee, you fill out your paperwork, you get registered. Now you've satisfied that part of the law. If you then run afoul of the law, because you violate one of the duties, you commit fraud, you solicit in a way that's prohibited or whatever it may be, Secretary of State doesn't have the enforcement authority. We have the enforcement authority at the AG's office. It's kind of a strange structure that, that you assume the purpose of a fee program is that the fees pay for the government conduct related to the program. But here, the fees go to the Secretary of State's office and they pay for registering and collecting fees. The enforcement part, we just absorb the cost. It's not about the money. It's about that's just really inefficient. I mean, if we want to bring a case, we got to go downstairs. We talk to them. We like them. We work fine together. But it just seems a very strange bifurcation. There are states that have it in different models. So, moving from one to another is just which group of states do you want to be in. I think it made sense to have this bifurcation maybe back in the mists of history when it started, because the AG's office back in the 70s or whenever, we didn't run any registration programs. We weren't filing anything. But today we run a bunch of them. We run the concealed carry licensing program, the private detective licensing program, the roofer registration program. Running a small registration program is just not an administrative burden for us. And we think the timing's good because, frankly, this program needs some new computer. It's not expensive, but it needs an overhaul on its tech. And if we're going to move it, we'd rather move it and then we overhaul it to fit in with our systems rather than overhaul in the Secretary of State's office and then we're still having a policy. So that's the rationale for all this. On the fee issue, let me just touch that. This got a little confusing in the House, probably because we didn't do a very good job of explaining it. Katie's here from the Secretary's office, and she can talk in more particularity. But here's the bottom line. There are, under the law, current and no changes, 3 different groups of people or entities that are regulated by this statute. There are charitable organizations, the charity that, unless it's exempted, has to register in order to raise money in Kansas, the professional fundraiser and the professional solicitor. Those are 2 different categories, and I always have to look them up. One of them is the telemarketing or fundraising company, and the other is the employee who's actually making the phone calls or otherwise making the pitch. I just never remember which is the solicitor and which is the fundraiser. Under this bill, the net effect, even though it says we're adding a fee to $25, the net effect is that the charitable organizations will pay $10 a year less than they're paying today. It's actually a reduction. And that's because of the way that the fee structure works at the Secretary of State's office. They've got an additional overarching layer, so Katie will explain it, but it's from 35 to 25 for the charitable organizations. Frankly, those are the constituents that are going to be most interested in this, I believe. The fundraisers and the solicitors, it's either a flat transfer, 25 to 25, net effect, and Katie can talk about that, or I'm still trying to figure out, because some of this is a little opaque. For one of them, there might actually be a $10 a year increase. That's it. And those are basically telemarketers. So I don't think the fee issue is a big one, but it's really confusing. But the bottom line is we don't think anybody's paying more, or if they are, it's telemarketers paying $10 a year. That's the bottom line. With that, I'd be glad to either stand down or turn it over to Michelle to talk about the other part of the bill, which is the proposed transfer of the Safe at Home program. Mr. Chairman.
Thank you, Derek. Question then, you said on the House vote, you think it was because it wasn't explained properly and the confusion over the fees?
Mr. Chairman, I certainly don't, I don't want to suggest that I speak for any House member. I don't. But as we watched the debate and realized, at least from our vantage point, what appeared to be a point of concern, there appeared to be a sense that we were raising fees on charitable organizations, and it doesn't. It actually reduces fees on charitable organizations. It's flat on the fundraisers, or it might be that $10 a year increase for one category. I'm still trying to sort that out. It's a really complicated, for a little program, a complicated fee structure. So unless, the issue wasn't the issue, which I know does happen sometimes around here, but unless that's the case, it appears to me the concern was there was worry about this as a fee increase on our charities. In fact, it is not, although I do understand why it looks like it is if you don't see how the parts fit.
Thank you. Does anyone else have any questions at this time? Senator Hawk.
Thank you, Mr. Chairman. Thank you, Mr. Attorney General, for being here. The fiscal note doesn't seem to speak to the charities unless I'm not reading it right. Is there going to be another fiscal note that will deal with the charities, or I might save that for Katie, but.
Katie can talk about that if you don't mind, Senator.
And my other question probably is a Katie one too, then what happened is roughly this is a $100,000 budget with all of the money, and that's generally not going to change.
Correct, generally, Senator, and just to be sure that, I don't want to fail to disclose something. I mean, right now this program raises directly it's about 90,000, isn't it, Katie? 89 or something like that from the fees in the program for the Secretary of State's office. For us, it would raise about 128. And you ask, so those are roughly 100, but you ask, why is there an increase? Well, the answer to that is, as Katie can talk about, in the Secretary's office, but not in our office, there is, in addition to these specific program fees, there's this overarching, I think they call it a technology and administrative fee of, I think the total is $15. So the entities that register are paying more. The charities, for example, they're paying $35. I think that's the right number, $35 in the Secretary's office. Anyway, they're paying $10 more than they would be now, because when they come to us, they get the $15 reduction because they're not paying the Secretary's administrative fee anymore. So even though we actually increase the underlying fee they're paying, the bottom line, the check they write, is less. I know that's bloody confusing. The net effect is there is more money raised for the program by about $30,000, not a huge amount, but there's actually less money collected overall because of the administrative fee not being collected anymore.
I sure hope we don't add this to Senate Bill 13, that tax transparency bill. They have to send out notices to explain that. So thank you. I appreciate your explanation.
Senator Fagg.
Thank you, Mr. Chairman. This might be a Katie question, too. Thank you for being here, Mr. Attorney General.
Thanks, Senator.
When you talk about the three different categories, I'm sitting there wondering the cost effectiveness. We're not picking up anything. If you get one complaint in a year and you start working on that, the cost that goes into that. So part of me wonders if I understand one, but maybe two and three could be up. And instead of people worrying about this is one that I would think could be higher. That's just my opinion.
Yeah, Senator, I mean, we were careful to try not to disturb any policy within the current law. We just wanted to make the administrative change. But obviously, if the legislature wants to address policy issues, you're certainly free to do that. I would say one other thing, and I didn't mention this, Senator, but the overarching philosophy of the statute, of current law that's not changed here, is that there ought to be transparency and certain standards for folks soliciting money for charitable purposes in Kansas. That's the general philosophy. And I mentioned a little bit the enforcement issues. We get a complaint that somebody's fraudulently soliciting or whatever, and we go after that. That's certainly true. But there's also a second benefit, I think, of the law overall, and that's just raw transparency. There is a website. It's a little outdated. It's something once we get past this, if we make the change, or even if we don't, we need to update it. We know it. We just kind of wanted to get this dealt with first so we know whose duty it is. But it's ks.charitycheck.org. That's the right URL, isn't it? ks.charitycheck.org. And we pitch that, to consumers all over the state all the time. It's a place you can go, and online, every registered charity, their financial information they have to file is available. So if you want to go look up, Derek's charitable entity, Inc., and see, our latest financials and see how much of every dollar you give is going to actually go to the charitable purpose versus our fundraising cost. That's all out there. So that is a separate purpose of the statute I didn't mention.
Thank you, Derek. Next, we'll have Michelle McCormick, Director of the Victim Services Office of the Attorney General. Michelle, welcome to the committee.
Thank you, Mr. Chair, members of the committee, and thanks for the opportunity. You have my written testimony in front of you, and so I'm going to keep my remarks pretty brief. I'm the Director of the Victim Services Division, as the Attorney General mentioned, for his office. And I'm here to just share with you that we think that the Safe at Home program, which is the address confidentiality program the revisor mentioned to serve victims and survivors of domestic violence, sexual violence, human trafficking, and stalking, would be a great fit in our existing Victim Services Division. We have exceptional staff who are specially trained to already serve crime victims, and we work with them every day. We also have existing relationships with the domestic violence agencies, the victim advocacy organizations across the state already provide training and technical assistance to them, and they act as the enrolling agents for this program. And so we think that if it transitions to our division, it could be a pretty seamless transition, and we could still continue serving victims of crime without missing a beat. And so that's essentially it. I wanted to speak to that today. So thank you.
Thank you, Michelle. Are there any questions for Michelle? Seeing none, thank you. Next, we'll have Katie Koppel with the Deputy Assistant Secretary of State with Communications and Policy. Katie, welcome to committee.
Thank you, Mr. Chairman. I am the infamous Katie Koppel. I'm representing the Secretary of State's office today, and it's a pleasure to see you all. We haven't seen you very much this session. House Bill 2079 would move the administration of both the Safe at Home program, that's its nickname in statute, it's known as the Address Confidentiality Program, and the administration of the charitable organizations in Kansas from the Secretary of State's office to the Attorney General's office. This legislation passed the House by a vote of 70 to 54 in early February. Similar legislation was considered last year through Senate Bill 293, so it probably looks a little familiar to you. It passed by a vote of 38 to 1 in the predecessing body to the existing Senate right now. Senator Hawk, to answer your question, part of the reason the fiscal note looks off is the Safe at Home bill was originally House Bill 2079. The Charities was House Bill 2080, and the House amended the two bills together into House Bill 2079. So that's probably why the fiscal notes seem a bit off. I'll talk real quick about the Safe at Home program. As previously mentioned, what it does is it provides a substitute address and free first-class mail forwarding to victims of domestic violence, sexual assault, trafficking, or stalking, and their children. Participants and their children may use the substitute address in lieu of on all public records in lieu of their residential address, and the intent is to help protect them from their abuser, stalker, trafficker, what have you. Victim services organizations throughout the state of Kansas are responsible for actually enrolling participants. They go over the program's benefits, and then our office, our role is purely ministerial. We accept that, and once they're enrolled, the participant's mail is forwarded to a P.O. box. Our staff goes and gets it and then forwards it on to their actual address. It's currently administered by one very diligent individual in our office, but she is not trained to work with victim services or victims the way the Attorney General's Victim Services Unit. And so again, we just feel that the victims would be better served by moving this program to the Attorney General's office. Moving on to the charities piece, I know that is the big star of this bill. Currently, our office receives registration reports from certain charitable organizations, solicitors, and fundraisers. Again, we don't have oversight capabilities. Our responsibilities are purely ministerial. Any allegations of fraud, we have to refer to the secretary, or we refer to the Attorney General's office. However, if they need any documentation, they have to come to us and get that documentation because we are the we have the ministerial, the filing, those sort of details. We do believe that this program would be better served by one agency rather than two. Last session, we did get quite a few questions on who has to register. So I will point you to KSA 17-1762, which contains a list of organizations that are exempt from registering. It's pretty substantial, so that probably helps narrow the scope of who has to register. In terms of fundraisers, those are generally considered individuals who are contracted by a charitable organization to either plan, manage, advise, consult, or prepare materials for soliciting funds. Individuals who are an employee of a charitable organization or individuals who provide a professional service like an attorney, they are not considered fundraisers. And then just to help give you an idea of what solicitors are, they are considered individuals who are paid by professional fundraisers to solicit contributions for charitable purposes. As the general said, we believe that much of the concern in the House was on the fees. Just for a little bit of perspective, is the Secretary of State's office is an entirely fee-funded agency. And so we just have different accounting mechanisms for filing and registration of documents. So the current Secretary of State fees for charities, for a charitable organization, that is $35 total. $10 of that is an administration fee, $5 of that is a technical fee, $20 of it goes to the state general fund. Section 5E in the bill lists the fees that would be paid to the Attorney General's office. It is $25 total, which is a net reduction of $10. The professional fundraiser registration, the Secretary of State's office charges $25. That is all an administrative fee. And Section 6C1 also would allow the Attorney General's office to charge $25 for fundraisers. That's the same amount. And then finally, the professional solicitor registration for the Secretary of State, it's a $25 administration fee. And Section 7D in the bill would allow the AG to charge $25. So with that, hopefully that helps answer your questions, and I'd be happy to stand for questions.
Questions for Katie? Senator Petty.
Thank you, Mr. Chairman, and thanks, Katie, for being here. So doesn't this bill, I mean, now we had money from the Secretary of State's office was going to the general fund, but now the Attorney General's office, the money is going directly to the Attorney General's office. Is this correct?
That is that's what I believe. Let's see, $25. Actually, it looks like the $20 would still go to SGF, and then because the AG would charge $25, and so I would assume, and it's just an assumption, that extra $5 would probably be some sort of administrative or technical fee for the Attorney General's office, but I'm not going to pretend to speak for them.
Okay, I'll ask that question then for them. Thanks.
Other questions for Katie? Seeing none, thank you, Katie.
Thank you.
We'll move on to Stephen Green, Philanthropy Roundtable. Stephen, welcome to committee.
Thank you, Chairman Billinger and members of the committee. My name is Steve Green. I represent the Philanthropy Roundtable. We just want to thank you all for the opportunity to provide support of House Bill 2079 on behalf of the Philanthropy Roundtable. To give you a little bit of background, the Philanthropy Roundtable was founded in 1991. Its mission is to foster excellence in philanthropy, to protect philanthropic freedom, and to assist donors in achieving their philanthropic intent. Today, the Roundtable has approximately 600 active members consisting of wealth creators, private foundations, community foundations, and family foundations, including some right here in Kansas. In fact, according to Foundation Stats, a national report by the Foundation Center, Kansas is home to 775 private foundations that give more than $215 million to charitable causes each year. Kansas's future will be brighter if we continue to foster a friendly environment for private charitable organizations to meet the needs of our citizens, enrich our culture, and solve pressing societal challenges. We believe, and this is important, that House Bill 2079 is a solid piece of legislation. We support it completely, and that it will align the regulation of nonprofits into the Attorney General's office. Their office has the expertise and resources to manage those areas while targeting bad actors. Our organization would respectfully submit and urge the adoption of an amendment to this bill. We work with the reviser and the Attorney General's office on this language, and it's before you in my testimony. Essentially, it says a state agency or state official shall not impose any annual filing or reporting requirements on a private foundation that are more stringent, restrictive, or expansive than such requirements in the Kansas statutes annotated or federal law. Essentially, this amendment means that that it protects the status quo in Kansas and will ensure that any new requirements for Kansas's charitable organizations go through the legislative process. This is a common sense reform that honors the transparency of the legislative process and will send, importantly, a message to those engaged in philanthropy that Kansas remains a friendly environment to do business. Philanthropy serves as a vital part of our local communities, and House Bill 2079 will protect the Kansas's charitable sector. Thank you for the consideration of this bill, and I'll be happy to answer any questions you may have.
Thank you, Stephen. Any questions for Stephen? Senator Petty?
Thank you, Mr. Chairman. Stephen, good to see you again. You mentioned the membership in the Philanthropy Roundtable, but I'm a little unclear. Is that nationwide or is that in Kansas?
Yep, so there are 600 active members, which is the membership of the Philanthropy Roundtable. The 775 that's referenced in Kansas may or may not be a part of the Philanthropy Roundtable. So that 775 is private foundations here in Kansas. Does that make sense? They may not be members of our organization, but there are 600 active members nationwide.
So the 600 is nationwide. You don't really have a number for Kansas.
Correct.
Of the members in the Philanthropy Roundtable. You gave us a number of how many private foundations there are in Kansas. Okay, thank you.
Thank you, Chair.
Senator Hawk.
Thank you, Mr. Chairman. Stephen, thank you for being here. Why are you suggesting this amendment with this budget? Had you proposed it when we had the other structure between Secretary of State and Attorney General's office?
For a couple reasons. If I think Mr. Chair, if I think I understand your question correctly, are you asking why wouldn't we propose it earlier this session?
Why now?
Yeah, that's a great question. I completely appreciate it. To be honest, this bill moved pretty quickly, and we caught it late in the process. And so part of it is that we saw the opportunity to really enhance or protect the regulations on nonprofits and charitable organizations with the Attorney General's office and this piece of legislation. So we thought this was a great time to offer the amendment or work on the amendment. It's similar to something that was introduced last year and had essentially green lights, but because of COVID, so like so many other bills, got hung up in the process.
Have there been any incidents of a state agency or state official imposing any kind of regulation that inhibits charitable giving?
Mr. Chair, thank you for the question. That's a great question, fair question, not that I'm aware of.
Okay, good.
Yeah.
Thank you. Thank you, Mr. Chair.
Other questions? Senator Fagg.
Thank you, Mr. Chairman. Stephen, is there any opponents to this that you'd be aware of?
No, sir, not that I'm aware of.
Okay, thank you.
Other questions? Seeing none, thank you, Stephen. Committee, first, are there any opponents that were not listed? Any neutrals that were not listed? Seeing none, we will close our hearing on House Bill 2079, and we will open a hearing on Senate Bill 264, enacting the Kansas Fights Addiction Act to establish a grant program for the purpose of preventing, reducing, treating, and mitigating the effects of substance abuse and addiction. We'll first have an overview by the Revisor's Office, Scott Abbott. Scott, welcome committee.
Thank you, Mr. Chairman, and good morning, committee. As the chairman mentioned, Senate Bill 264 would enact the Kansas Fights Addiction Act to establish a grant program for awarding grants for preventing, reducing, treating, and mitigating the effects of substance abuse in the state of Kansas. The bill provides that the Attorney General would remit to the state treasurer all monies that are received by the state pursuant to opioid litigation, dedicated by the terms of the litigation for the abatement or remediation of substance abuse or addiction. The money would be credited to the Kansas Fights Addiction Fund, which would be created by the bill. The money in that fund would be used for grants approved by the Kansas Fights Addiction Review Board to qualified applicants for projects and activities to prevent, reduce, treat, or mitigate the effects of substance abuse. The bill would create the Kansas Fights Addiction Grant Review Board under the jurisdiction of the Attorney General. The board would have 11 members. At least one member would represent each congressional district of the state. The members would have expertise in the prevention, reduction, treatment, or mitigation of the effects of substance abuse, and would include members appointed by the Attorney General, the governor, legislative leadership, and various stakeholder groups. The bill also prescribes requirements for the conduct of meetings and business by the board. It provides that the board will receive and consider applications for grants and consider awarding grants to support services throughout the state, with some factors to consider, including science and substance abuse prevention strategies, consulting with appropriate public and private entities for coordination of drug abuse and addiction, and approving grants only in compliance with the requirements of the Act. It also allows the board to establish conditions for the award of grants and would require assurance and subsequent review to make sure that those conditions are being met. Would also give preference to qualified applicants that are not otherwise seeking or receiving funds from opioid litigation, and would give preference to expanding the availability of the Certified Drug Abuse Treatment Program. The bill would provide that the Attorney General would provide administrative support for the board and would allow the Attorney General to enter into agreements with the Sunflower Foundation for that support. It also provides requirements for those agreements. The bill also imposes some requirements on members of the board, specifically that they will not receive compensation or expenses, and each member shall file a statement of substantial interest, and a member will not participate in the consideration of any grant application for which that member has a conflict of interest. The bill provides that the Attorney General and each municipality of the state is solely responsible for paying the costs of opioid litigation under their respective authorities, not using the funds in the Kansas Fights Addiction Fund. The bill would also provide that on and after January 1 of 2021, so this year, no municipality shall file or maintain opioid litigation without prior approval of the Attorney General. And if a municipality has already filed such litigation, the municipality is required to withdraw from that litigation unless the municipality receives approval from the Attorney General. This prohibition would not apply to any litigation filed prior to January 1 of 2021. The bill would also require the board to file each year, not later than March 1st, a report of activities to the Speaker of the House, the President of the Senate, the Governor, and the Attorney General. The report would include an accounting of monies deposited into and expended from the Kansas Fights Addiction Fund, a summary of any grant that has been approved by the board in that year, and an explanation of how the board's actions have complied with the Act, and any other relevant information the board would choose to provide in that report. The bill would take effect upon publication in the Kansas Register, and Mr. Chairman, I would be happy to answer any questions.
Scott, questions for Scott? Senator Kirshen?
Mr. Chairman, how much money is in that fund for that purpose?
Scott, do you know?
I'm
How
sorry, I
much-
couldn't hear that. Could you repeat, please?
How much money is in that fund that they use for addiction?
Well, Mr. Chairman, Senator, the fund would be created by the bill, and it would consist of all monies that are recovered by the states. Perhaps the Attorney General or another conferee might be able to provide some idea of what amount of money that would be.
I understand the fund. I knew it was, I just want to know whether there's ongoing, it has to have some money in it. or isn't there?
Mr. Chairman, Senator, there would be no outside appropriations to this fund, no transfers to this fund. The fund would consist entirely of that recovered money.
Okay, I understand that.
Senator Hawk.
Thank you, Mr. Chairman. Scott, does it take litigation from some municipality, et cetera, to get money into this fund, or is the Attorney General a party to some litigation that would ultimately result in money coming in?
So the money coming into the fund would be the money recovered by the Attorney General in opioid litigation.
Okay. And my second question, are there any municipalities that have filed litigation prior to that January 1 deadline?
I'm sorry, Senator, I don't know that for certain.
Okay.
Perhaps somebody else could provide more information.
But I always try to give them a heads up. Thank you. Thank you, Mr. Chairman.
Other questions? Seeing none, we'll start out with proponents. We'll have first the Attorney General, Derek Schmidt.
Thank you, Mr. Chairman, and thank you for, by the way, stacking these two bills back to back so we could deal with them both on the same journey over. So I'll be happy to talk about whatever level of detail you want. I will try not to get too far down a rabbit trail here, because once I get started talking about opioid litigation, all kinds of strange details come out that I'm suspecting many here won't care about. So if I get off track, just put me back. But there really are three significant public policy issues we're trying to present to you with this bill. Actually, two with the bill itself, and then a third with the attached balloon. And so I'm going to try to frame those up on why we're here with this, and then I'd be glad to talk about particulars with any of those if you're interested. The bill, as introduced, does two general things. First of all, it gives us a vessel into which we can deposit funds recovered from the state's ongoing or future opioid litigation, and I'll talk about that in a moment. That is the one part that I would implore you, whatever else you do, please give me something on that, because otherwise I'm going to have recovered money and have nowhere to put it and no way to use it for the purpose the court ordered, which is, generally speaking, for abatement of addiction. That's a very broad statement, but generally that's true. That's what most of the bill does. The second major policy piece that we could have introduced as a separate bill, but we didn't because it's related to the opioid litigation, is Section 6, which is the provision that proposes to extinguish future potential lawsuits by public entities in Kansas after a date certain related to opioids. And you can do one, you can do both. I would ask you to do both, but they are in fact separate policy choices that serve different purposes, and I'll mention those. And then the third is the balloon, which after we had this hearing in the House earlier this week, we were able to sit down with, in particular, the League and some of the cities who, there's a lot of details, the devil's in the details on this more than most, and worked out language that I think they will tell you is agreeable to them and makes their members much more comfortable, and we're certainly supportive of. So those are the three sort of buckets, if you will, of policy issues here. With respect to the first one, a vessel to receive this money and to disperse it for its intended purpose, which is generally speaking to address addiction. Kansas, like many states and many municipalities, Senator Hawk, including many in Kansas, I don't have a firm number, but we think it's around 30-ish cities, mostly cities, some counties, that have filed against some or all of the opioid defendants. And there's a lot of asymmetry here. There's multiple lawsuits, and there are different claims in the different suits, and there are different plaintiffs in the different suits. But for the state's perspective, I made the decision early on that we were going to handle these cases in-house, so we're not paying private counsel. That was a policy judgment on my part. I think it turned out to be prudent. And the only reason I mention that is because one of the issues in some of this litigation is that a lot of our municipalities made a different choice, which was their right under current law, and this doesn't change that. But how to pay those private attorneys that are representing many cities and counties is the single biggest sticking point in resolving the next wave of opioid litigation that's still pending, and we're close. From the state standpoint in Kansas, we have reached at least agreements in principle, and in one case a full agreement that's now court approved, to resolve the state's claims. The first was against Purdue Pharma, which has gotten a lot of attention. They, of course, were the principal. They were the manufacturers of OxyContin, which has gotten a lot of attention and a lot of blame for the last 20 years of significant opioid addiction and the associated costs. We sued Purdue and then entered into a broad framework for a settlement with them right before they went into bankruptcy. And we've been slugging it out in bankruptcy court with them now for, what, about a year and a half, 2 years, something like that, Chris, and continue to do that. So we have a deal with Purdue, at least in principle, but we have no money from Purdue, and we're not going to anytime soon until the bankruptcy proceeding is concluded. Second, we reached a similar posture with Mallinckrodt Pharmaceuticals, or whatever the formal name is. Similar types of claims, similar types of alleged conduct. Similarly, we reached this broad agreement in principle with them, and similarly, they went into bankruptcy. And so we are slugging it out with Mallinckrodt in bankruptcy court. Although we have a general agreement on how to resolve the state's claims, there's no money, and there won't be for a while until the bankruptcy proceeding is concluded. Third, and these are in order of how they happened, third, we reached, the state reached a settlement agreement with McKinsey & Company. McKinsey is a large national consulting firm. We'd essentially accused them of aiding and abetting, for lack of a better term, for assisting predominantly Purdue, but perhaps some other manufacturing clients of theirs, in falsely marketing the benefits and downplaying the risks of opioid use and resulting in addiction. We have reached a settlement with McKinsey, as of many other states. That settlement has been approved by the court, and there is actually going to be money coming from it, which is why we're in front of you today, because when that money arrives, I have no place to put it, and I have no way to ensure that it is used in the manner that the court ordered as part of the settlement agreement, which is it's supposed to go toward dealing with the costs of addiction, breaking it. Mitigation is what it's generally called. And there are going to be others down the road. There are future settlements not done yet, but they are coming. I have a high degree of confidence. So the major thrust of this bill, all but Section 6, is about creating a vessel, a fund for me to put that money in, creating a board that will decide how it gets spread around Kansas, so it's not just me trying to decide, in a manner consistent with the settlement terms. That's the major purpose of the bill, and we tried to draft it in a way that it's not just about McKinsey, even though that's the money that is going to be on the table shortly, but it's available for future settlements as money flows, because it's likely to flow over a period of years. Senator Kirshen's question, the McKinsey settlement is about a $4.8 million settlement for Kansas. That money will come over 5 years. It is front-loaded. I want to say it's 3.some million, 3.8 the first year, and then it ramps down to hundreds of thousands in the out years. So that'll be the first money that actually would go into this should you enact it. That's the major purpose of the bill. The second thing on Section 6, I won't dwell on it, but it serves an entirely different purpose, which I believe is valid, but it is a different public policy decision for you. What I believe is likely to be the next settlement, certainly what I think is the most ripe, is we are engaged and have been for several years now with settlement discussions with the three major distributors of pharmaceuticals in the country, Cardinal, McKesson, and AmerisourceBergen. And that's a much more complicated case than McKinsey. It's even more complicated than Purdue or Mallinckrodt, in part because there's a lot more money on the table, and so it won't be surprising there are a lot more plaintiffs, including a lot of municipalities, but not only municipalities, there are also some private plaintiffs in it. That case has been MDL'd, we call it. All of those federal lawsuits have been pulled into singular multi-district litigation in Cleveland. There also are separate state lawsuits that aren't subject to the MDL process, and so it's, suffice it to say, it's a very complicated litigation circumstance. We are at, and it's been publicly reported, so even though it's not done, I feel comfortable talking about it. We are at a point where we have, I think, agreement among the plaintiffs' counsel representing the municipalities in the MDL, the states, and the distributors on the broad outlines of a settlement. And it's large. It's about a $26 billion settlement overall. Those payments will be made over a number of years. What we're hung up on now and have been for some time is how the plaintiffs' counsel that want a lot of contingent fees out of that money are going to get paid, because unsurprisingly those, including us, that didn't give away part of our settlement to the attorneys up front would really prefer not to have to pay other parties' attorneys' fees. So it's a complicated bargain. In any event, the reason I'm telling you all of that is to explain Section 6. One of the provisions in that settlement, and I expect we will see it perhaps in others in the future, the companies, the defendants, one thing that is very important to them in a settlement negotiation, they want what they call global peace. In other words, if they're going to settle with the state of Kansas, they want to make sure that after they've done their settlement, they don't wind up getting sued by 600 individual cities in Kansas, subdivisions of the state, or 100 counties. Because from their vantage point, and we can argue our side of the ledger all day long, but from their vantage point, it's all the same claims for the same group of people, the same citizens, the same harm, and they're just not interested in settling with the state, or at least they're not willing to pay as much to settle with the state unless they have a confidence level they're not going to get sued by, everybody else that's in the state. They recognize that there are already many plaintiffs in the state that have already filed, and that's sort of factored into the settlement discussion. So those cities and counties that have already filed prior to January 1, that's all factored into the dollar amounts of the settlement. The issue is, in order for the state, us, to maximize the amount of money that will come to us under that settlement, it's a sliding scale, part of the bargain is we have to minimize the risk that other state entities are going to sue them after the deal's done. In other words, and I shouldn't pick on Stockton, I don't know why I'm picking on Stockton, I've just been using them to illustrate. They're not worried about, they know Wichita's sued them, and Sedgwick County and Overland Park and the state of Kansas, they got all that, and they factored that into the bargain. And they're really not worried that in Stockton, in my example, I don't know, Stockton's going to show up and sue them in a year. But they are really worried that the same national plaintiffs' law firms that have been out signing up all these municipalities to sue are going to go knock on the door at Stockton or Cedar Vale or Neodesha after this deal is done and try to get a second round of clients to basically relitigate and get more money out of the same claims. That's what the companies are worried about, legitimately or not. That's what they're worried about. And therefore, they are willing to pay the state more in settlement if we can guarantee to them that's not going to happen. And that's what Section 6 is designed to address. By saying we're going to extinguish local claims going forward for all this past conduct, we can then truthfully represent you aren't going to get sued again for the same thing out of a subdivision of Kansas, and therefore we will be entitled to the maximum amount of dollars from the settlement we're entering into on that sliding scale. So that's what the purpose of Section 6 is, again, a different policy choice from the others. And finally, the attached balloon, I'll leave it to others to talk about details, but suffice it to say, as we've been working through this, I've been very grateful for the many efforts of individual cities as well as the league and individual counties as well as the association. We're trying to get everybody as happy as we can because everybody has different claims against the same defendants in some cases. And the bottom line is the balloon that you have there is what we worked out with the league after the hearing on Tuesday in the House to, I believe, resolve the remaining concerns from their vantage point. So we're all trying to get to yes here and not just dump those issues in your lap. Mr. Chairman, I'd be glad to either be quiet or answer questions or whatever you prefer.
Are there any questions? Senator Hawk.
Thank you, Mr. Chairman. Thank you, Attorney General. I read something the other day about Purdue Pharma and this bankruptcy, and that the Sackler family, I think, who is a major stockholder in Purdue, will still be able to acquire a lot of income post-bankruptcy because they still have the patents on OxyContin and some of those other opiates. Is there any way in this particular instance where we're not going to be limited in how we settle, where they use bankruptcy to sort of get through the initial phase, but still have a fairly large cash cow that, in a way, when I look at the damage that all of us are paying for in lives and government costs and healthcare costs, that doesn't seem to be fair to me. Normally, I would say, yeah, if you get bankruptcy, give you a fair start. But in this case, so is there any legal way for us to be able to not settle too quickly and be able to do what I heard or read in that publication?
Senator, the interaction between Purdue Pharma, the corporate entity or entities, and its essentially owner, the Sackler family, and there are multiple family members who have substantially varying degrees of involvement in the operation of the company over a period of time. It has been perhaps, other than the attorney's fees issue, the single biggest sticking point in the Purdue litigation. I'm quick to say we haven't reached settlement, nor is there a judgment, so I can only tell you the allegations that are public, and, the other side would dispute them. But essentially, those of us on the public entity side of the ledger have accused both the members of the family as well as the company. They made billions, with a B, billions of dollars off of what we believe were the unlawful sales of OxyContin predominantly. We then accused the family, members of the family, of bleeding off a substantial amount of that money out of the company and then parking it in lots of places that we can't reach. Obviously, they have a different perspective on what happened, and that has been a huge point of negotiation, both in the early settlements with Purdue and the associated family members and in the bankruptcy proceeding. There, just to illustrate the point, different family members have different levels of involvement. They were compensated for different purposes. They have different defenses available. They have different levels of culpability from our vantage point. And proving all of that is a very difficult proposition over time. So I guess all I can tell you is all of those issues have been on the table from the start. I don't think we give up anything by not being able to sue them after, because those issues will be resolved to the fullest extent we can resolve them in the context of the bankruptcy proceeding and the pending litigation. I will tell you, perhaps the public report you saw, because this was publicly reported recently, the members of the family have agreed to put a significant additional amount of what they would view as their personal money back into the settlement, back on the table. And so you can think of that from our vantage point as almost a clawback of some of that money within the bankruptcy framework. Bottom line, we won't, as the plaintiffs, we won't get everything we really think we should, but we will get more than they want us to. Is that a fair description, Chris? Yeah. Chris Teeters is our assistant, who's our point of the spear for us on this litigation. So,
Senator Petty.
Thank you, Mr. Chairman. I was looking at the balloon amendment, and so if I'm understanding that correctly, that of the money that comes in, 75% is going to be going to the Attorney General's office, 25% is going to be going to what's referred to as a municipality's account, and that those municipalities are the municipalities who have not sued. Is that correct?
Not exactly, Senator, and if I misstate anything here, my friends in the league will make sure we're on the same page here. But the real challenge is there are municipalities who have sued. There are municipalities who haven't sued. Whether you've sued or not doesn't necessarily reflect whether you've incurred harm or whether you have addiction that needs to be dealt with going forward. And then, the state's interest, you're right, the money would go to the AG's office to administer, but we don't get any of it. That all goes into a grant pot that then applicants, either not-for-profits or government entities that provide services, would apply for. Resolving that sort of triangular dynamic has been a real challenge in all of this. Because, for example, there are some municipalities, I've talked to some of them, that made the affirmative decision in Kansas not to sue because they thought it was ill-advised to take on the attorney's fee burden. They didn't want to give away a third of a potential recovery to plaintiff's counsel. They didn't think they needed to. There are other municipalities that feel very strongly that because they took on that burden, they helped kind of move the whole ball towards settlement. We wouldn't be here today but for that. The state, I already mentioned, I made the judgment we weren't going to retain outside counsel because I thought I'd have to recover, a third more in order to get to the starting line if we did that. So lots of different dynamics. The balloon, the 75-25, the concept there is to incent municipalities to give up their claims that they might bring or they have brought. And in exchange for that, they get access to what I'll call a set-aside amount of the overall recovery money that only municipalities can access. So therefore, they're not in competition with private providers, for example, of drug and alcohol services. I think overall, you think that's a fair way to describe what we're doing here, Amanda? And they can talk in more detail. I don't mean to defer to them. It's just they got members on both sides of this. Some sued, some didn't, different interests, and we're just trying to find a way. From my vantage point, I just want everybody that, has a chance to do some good with the money to have access to it. And I wish we didn't have to pay all the costs it took to get here, but we do. And so that's kind of where we are. There's no magic in that. 75-25 is a split that some other states have used. We're not the only ones struggling with this. I mean, this is a dynamic in all of the states that that didn't just extinguish municipal claims from the start. And there are other issues with those, you know. So 75-25, I think, is a relatively common, or at least there's precedent in some other states. It's sort of arbitrary. Quarter goes, the municipalities get access to that pot. The other 75, anybody gets access to it that's provided services.
Other questions?
And I'm sorry, one other thing, Senator, I might add, I really don't mean to filibuster. It's just one of the things I felt strongly about and still do. I don't think that those jurisdictions that chose to litigate should, and pay private counsel for that purpose, I don't think they should pay their attorney's fees out of the recovery that everybody's supposed to be sharing for mitigation. That's a position I've taken from the start. I recognize in the real world that many of those jurisdictions that did litigate, they've got attorney's fees to pay. I mean, they got to do it, right? And so one of the differences, part of the balloon, is in the state fund, the 75%, nobody can use it. Municipality, state, nobody can use those monies if they're granted them to pay their litigation costs. In the 25%, you would be eligible to apply for and receive attorney's fees or litigation costs out of that. So there is a bit of an asymmetry in what the money can be used for. It's part of the bargain of trying to keep those three different groups satisfied.
Senator Fagg.
Thank you, Mr. Chairman. Mr. Attorney General, I was just double checking to make sure I understood. You talk about these costs being separated from your office. Who pays for that? Does that come out of your budget then?
Sorry, Senator, which costs are we talking about?
I'm talking about your litigation costs.
Yeah. So from the standpoint of the state litigating these cases, the ones we're talking about here, I made the decision early we would just, we wouldn't hire private counsel, so we aren't going to get an invoice for the cost. Chris and other employees are our cost, and I made the decision we would just absorb them. And the reason I did that, separate and apart from, I just didn't think it was prudent on our part to give away part of the recovery as a contingent fee before we started. Part of this is not the issue before you today, but you know, some of you have seen me animated on this before. Part of what really irked me here is there were literally law firms that came and knocked on my door, said, will you hire us on a contingent fee basis to sue? I said, no, we're going to handle it ourselves. And then the same firms went out and knocked on city and county doors and got some of them to sign up because it's a promise of free money. And that's made this a much more complicated settlement on the back end. But that's a problem for another day. That is not what we're doing here. So I made the decision to absorb the cost. Now, there might be somewhere down the road, if we got to add another body in addition to Chris on a future, if the load gets too heavy, we might try to find a way to come back to you and get a little bit of the recovery money. But honestly, I just thought our cost is relatively low compared with the size of the settlements. And it's just much cleaner for me to say we're not asking for any of the settlement money at the AG's office. And that was worth something to me to be able to say that. And so that's why we're doing it that way.
Thank you, Derek. We'll move on to other proponents. And I might ask the proponents going forward here, if you kind of don't read your testimony, be kind of brief. We are short on time. So next we'll have Allie Devine with the Alliance of Boys and Girls Clubs. Welcome, committee, Allie.
Good morning, Mr. Chairman, members of the committee. As you said, I'm Allie Devine, and I want you to just, I'm going to summarize this very quickly. The Boys and Girls Club across the nation have been watching these opioid cases. In many other states, they've been a part of the settlement. They've been eligible for applicants to further fund their prevention programs. Youth prevention is a #1 priority at the Boys and Girls Clubs. When I read the bill, I was a little concerned that we may not be an eligible applicant because the definition was such that it tied it to basically being a litigant. And I was confirmed with the AG's office that, in fact, we are an eligible applicant. I put that in our statement, so in the future, we'll have some basis if we want to make an application and somebody says, no, you're not an eligible applicant. We think, and I just confirmed with the league attorneys too, that we think the intent was clear, that it was intended for nonprofits such as our Boys and Girls Clubs, and that's what's been confirmed by the AG's office. And we thank them for their work, and we look forward to working with all of you. Thank you.
Thank you, Ally. Any questions for Ally? Seeing none, thank you, Ally. Next, we'll have Michelle Ponch, Association of Community Mental Health Centers of Kansas. Michelle, welcome committee.
Thank you. Chair Billinger and members of the committee, my name is Michelle Ponce. I am the Associate Director of the Association of Community Mental Health Centers of Kansas. We represent all 26 mental health centers across the state who provide services to Kansans needing them regardless of ability to pay, making them the safety net for Kansans with behavioral health needs. We appreciate the opportunity to testify in support of Senate Bill 264. A majority of our community mental health centers already provide substance use disorder treatment and services, and we anticipate that more will do so over the next few years as community mental health centers transition to the certified community behavioral health clinic model, as substance abuse treatment is a required service component of that model. We strongly support the intent of the bill to provide funding via a grant process to qualified local programs for prevention and treatment programs, and we appreciate the allocation of an appointment to the newly created Grant Review Board. As written, one appointment is to be made by our association in consultation with the Kansas Association of Addiction Professionals. It should be noted that our associations are separate nonprofit legal entities, each with our own governing boards. Our association has a broader behavioral health focus, while CAP's focus is specifically on addiction and treatment and prevention. Given the two distinct perspectives, we respectfully recommend each association be allotted its own appointment to the board. In conclusion, we applaud the plan to distribute funding in a manner to best meet the needs of our local communities, and we look forward to contributing to the work of the Grant Review Committee. Thank you.
Any questions for Michelle? Seeing none, thank you, Michelle. Committee, I'd point out we also have written only from Brandon Jones, President of the Kansas County and District Attorneys Association, and Stuart Little, Behavioral Health Association of Kansas. We'll move on to opponents. We have one opponent listed, Nick Reniker, is a private citizen. Nick, are you here?
Here, Mr. Chairman, can you hear me okay?
Nick, you on WebEx? Thank you. There he is.
Yes, sir. Thank you, Mr. Chairman, for allowing me to speak today. Appreciate the time taken for this committee hearing. I am an opponent to this bill on kind of a narrow scope, and to avoid commentary on positive or negative eugenics, forced sterilization, or the work of Darwin, Sanger, Galton, and the like, which in their time was considered science, with some effects still in practice today, like fingerprinting and IQ tests, I will try instead to simplify my opposition to this bill. The government, it seems, does a good job getting people addicted to government and creating crises. We have seen that in the last year with masks and vaccines in the response to SARS-CoV-2, including principles of virtue signaling and peer pressure, along with media and Hollywood programming. And also with the pain as a fifth vital sign era, which was a catalyst to the opioid crisis itself. Then, when there is enough media coverage or public outcry or other defined threshold, the government then tries to come to the rescue by growing government even more to fix the problem it helped to create, somewhat like this bill. The difference, though, is this money is coming in, and I do not fault the proponents for trying to find a responsible and constitutional way to spend it. However, when it comes to substances or substance use disorder defined by the most current edition of the Diagnostic and Statistical Manual for Mental Disorders, there is an equity issue that needs resolved. The policy trajectory concerning psychoactive substances involving the FOSB protein expression is going to go the way of more liberty or more prohibition. Responsibility, treatment, therapy, entertainment, pleasure are all germane and interesting topics, but simply put, when we idolize certain substances because of a physical or desirous response and it becomes a godlike thing, there are consequences that are clearly negative to the person's health, family, community, and last but certainly not least, legal issues. Now, for example, my wife and I run a restaurant, and I make fun of our pie because I tell the Hutchinson Correctional members the officers there that this is our definition of contraband. Now, I guess this apple pie would kind of be more like medical pie because it does have some apples in it. But this chocolate pie, which is not very healthy and has a lot of diabetes forming sugar as a white substance, probably is more of a recreational pie. And we also have these caffeine delivery devices, which we call coffee cups, that provide psychoactive there. Now, I say this not to make fun of the situation, but to try to put it in an equity sense, because both sugar, caffeine, nicotine, and alcohol, and gambling for that matter, are some constitutional amendment rights, but also the others are exempt from the Controlled Substances Act. We all have an endocannabinoid system in our bodies, which is one of the reasons I believe that access to cannabis is a natural right. Instead of this policy trajectory of outlawing natural occurring substances and then monopolizing the synthetic substances and the capitalistic qualities of them, I think we need to look at it a little bit differently. And that's not even getting into the behavioral addictions of sports, gambling, even politics and things like that. So anytime also in Section 6, we talk about extinguishing local control, I get a little suspicious, or, you know, my spidey senses or whatever goes. So I'm not really sure about that either. Now, if you want to talk about the DSM as a referral source, or my own personal testimony concerning idolatry, pride, and fear, or even my concern about a transgender federal assistant health secretary promoting the idea that my planting a certain seed, watering it, feeding it, and using it with liberty is an addiction, mental illness, or a crime, let me know. Otherwise, in conclusion, this money should go to opioid issues exclusively until at least cannabis is descheduled from the State Controlled Substances Act. Thank you, and I will stand for any questions.
Thank you, Nick. Are there any questions? Seeing none, thank you, Nick. Next, we'll move on to neutral. We have Alexandra Blasey, Kansas Board of Pharmacy, and she's on WebEx, I guess.
I am here, sir.
Alexandra,
Can you hear
are
me?
you there? Yes.
Thank you, Mr. Chair. I'm Alexandra Blasey. I'm the Executive Director of the Kansas State Board of Pharmacy. I greatly appreciate the opportunity to provide some brief testimony neutral on Senate Bill 264. As you know, the Kansas Board of Pharmacy is home to the Kansas Prescription Drug Monitoring Program, which we affectionately refer to as KTRACS. Since I know many members of the committee are familiar with this program, I will not review it, but as you will recall, our mission is to prevent the misuse, abuse, and diversion of controlled substances, which includes opioids, while ensuring continued availability for legitimate medical use. As you know, we have struggled over the years to find a permanent funding solution for the KTRACS program, and while we've presented a budget this year that does reflect funding for fiscal year 22 and 23, and we do have plans for further out years, we have also discussed with the other stakeholders, as well as the Division of Budget, the opportunity for funds from any opioid litigation settlement, to help support the KTRACS program, at least in part. And so in my testimony there, you have, of course, the funding that's been proposed for fiscal year 22 and 23. And the board's simple ask today would just be that this committee consider an opportunity for some of this funding to potentially support the KTRACS program, at least in part, since our objectives do align and support the intended mission of the opioid litigation settlement funds, specifically in the world of prevention, as well as reduction and treatment of any substance-related issues. And with that, I would be happy to answer any questions, Mr. Chair.
Thank you, Alexandra. Questions? Seeing none? Senator Hawk.
Alexandra, do you think the way the bill is written, it would allow us to fund part of KTRACS through this revenue source?
I believe an amendment would be necessary because there is no specific carve out for the KTRACS program. While I don't necessarily believe that KTRACS would be excluded from applying for funds under the grant-funded program that would be the same for other not-for-profits. Since the KTRAX is a government entity, we are structured a little bit differently. And so I would just greatly appreciate the opportunity to have a specific line item that would provide a certain amount of support, even if it's just for the software specific items within the KTRAX program for supportive funding. But I believe that that would have to come in the form of an amendment.
Thank you. Thank you, Mr. Chairman.
Attorney General Schmidt, could you speak on that briefly, just whether or not they are excluded or not from sharing in these funds? Or one of your staff? They were wondering if they would be eligible for any type grant funding for KTRAX, which is, the pharmacy piece.
My gut answer is I think so, but I'd sure want to, let me look at this. I think so, but let me double check before you rely on that answer.
Okay.
I think so. I don't think there's anything that excludes them, but let me check.
Okay, that's why I was wondering if they were excluded or if it needed an amendment or not. Thank you. Okay, any other questions for Alexandra? Next, we'll have Eric Sortris, Kansas League of Municipalities. Eric, welcome committee.
Good afternoon. Oh, still good morning, Mr. Chairman and members of the committee. I am Eric Sartorius, League of Kansas Municipalities. I don't have any pieces of pie or anything to show you to make you any hungrier than you all probably are already. I would have eaten them by now anyway. I think with this legislation, what we all can agree on, the legislature, attorney general, local governments, is we want to see how we maximize these funds to help the most people that have suffered harm from the use of opioids. And the question is, how do we do that in the right way? And that's been the struggle over the past several months. So as we've talked about this topic with our cities, it's clear that their interests really vary. Some have sued and have litigated, as the general said. Some look to him to kind of carry the ball for the state and the cities. However, the commonality is they want to see the impact lessened in these funds used in that way. We feel strongly from our members that these should be used in both rural and urban settings, because while there may be more population in the urban areas, this has been an issue that most definitely has impacted our rural communities very strongly. As the Attorney General noted, it is in the best interest of the state, and in turn the cities and counties, to maximize their recovery. And one way to do that, as he noted, is kind of clearing or closing that area where there might be future litigation. However, it's also equally important for the cities and counties too that they don't enter that decision lightly to extinguish their claims, especially with, as the bill was written, no guarantee of seeing any funding. The bill as drafted was unique in its approach compared to other states, that it didn't have any funds set aside for locals to incent them to extinguish those claims. And so City of Overland Park offered an amendment Monday. Afterward, we sat down with the Attorney General, who graciously took significant time to sort through these issues. And what we think we've reached with the 75-25 split is that cities, both the ones that did not litigate and want to see some funds, which is the vast majority of your constituents, as well as cities that have litigated but are willing to extinguish their claims, could have access to that portion of the funds. Now, there's still an option for the cities to move straight ahead and say, no, we're going to be able to do better on our own if they've already filed a suit. But they will not have access to any of the state's funds. And I think that strikes a good balance where you don't get into a feeling that you all might have that a litigant is double dipping or trying to come at it a second way. And then finally, I would note on that 25% that will come to cities, they can then do like many of them do with alcoholic liquor funds, turn around and find those providers in their community that have the skills and have the experience to help folks with recovery and addiction. So it's not necessarily going to be a question of the cities just receiving money, but it has to go to the same uses as the bill lays out. And then I'm not an attorney and I don't work for the Attorney General, but I looked at the qualified applicant piece of House Bill 2412, and to the Board of Pharmacy's question, it says any state entity, and then the language talks about that provides a service that focuses on addiction and recovery and things. And I suspect you all could probably see them make a viable case that the K-Track system does help in those areas. And with that, I would stand for questions. I also want to make sure I say, with adoption of that amendment, we would then be supportive of this legislation.
Thank you, Eric. Any questions for Eric? Seeing none, thank you.
Thanks, sir.
Are there any other neutrals or opponents to this bill? Seeing none, we'll close our hearing. Yeah, can you wait till after we're done? Okay. Okay, at this time, we're going to reopen our final action on House Bill 2018 that we worked yesterday. We'd missed an amendment, and so at this time, I'll recognize Senator McGinn.
Thank you, Mr. Chair. I think I'm on. Yes, I have an amendment that was made aware to me a little bit late. This has to do with the State Employees Health Care Commission. And what this does is I'm just going to go ahead and hand it out so you have the paper in front of you. Yeah.
Yesterday we did that.
It didn't get read in, so probably go ahead and do that. Okay. I think that's a good idea.
Senator Clays.
Mr. Chairman, I make a motion that we reconsider House Bill 2218.
Have a motion by Senator Clay, second by Senator McGinn. Any questions or discussion? Seeing none, Senator McGinn.
Thank you. What you'll see on page 1 is that this commission has been governed by 5 individuals. It used to be in the Department of Health and Environment. It's now in administration, and I think that was a very good move. But the history has been the Department of Administration has always chaired that meeting as well. And so what this amendment does is that we are going to add 2 extra members to this. This Healthcare Commission, they talk about the health care that's provided to all state employees, including legislators, and talk about what programs should perhaps be added, what programs should, go away, and that type of thing. And then, and I'll get to the cost effectiveness here in a minute, but what this does is adds 2 more people. One is appointed by the president and one by the speaker. And it can't just be anybody. They have to be on a budget committee to be considered to be appointed. It also changes the chairmanship. So in odd number years, it would be the Commissioner of Insurance, and on even number years, it'd be the Secretary of Administration. Let's see, also you'll notice here somewhere, not more than 5 members can be a member of the same political party. And then on the second page, there's a couple of adjustments, and which gets back to the point of taking a closer look and having a little bit more representation on there. The State Employees Health Care Commission shall balance the health care needs of the state employees at an affordable cost to the employees with the financial impact and consider the financial impact on the state. The rest of that language is already in current law, so if you go to attachment 2, the recommendations shall include a report on the current and projected reserve balances, including a percentage of the total plan expenses For any reserve over 10% of the expected plan expenses for the next year plan, the commission shall provide recommendations for reducing reserves by minimizing increases in employee contributions or cost-sharing requirements. So, Mr. Chairman, the effort here is to have more eyes on our health care program that is provided to all state employees and elected officials. But it's also to take a look at the balances and figure out if there's a way to decrease those costs. Over the last decade, I believe, if you look, the cost to the employee using the health care has gone up extremely. And so I know there's a lot of messy stuff in here, but I think I've highlighted those important factors for it.
We have a motion by Senator McGinn and a second by Senator Clays. Discussion. Any questions on the amendment? Seeing none, Senator McGinn, you can move your amendment.
I move House Bill 2218. Well, I move my amendment on House Bill 2218.
Heard the motion. All in favor? Aye.
Aye.
Opposed? Motion carries. Senator McGinn.
Now I move House Bill 2218 as amended out of committee favorably for passage.
Motion by Senator McGinn, second by Senator Clays. Any questions or discussion? Seeing none, all in favor? Aye. Opposed? Motion carries. Thank you, Senator McGinn. Next, we'll move on to a hearing on House Bill 2087, limiting the review of certain rules and regulations by the Director of the Budget. First, we'll have a overview by the revisers. Jill Walters. Jill, are you there?
Yes, sir, I am, sir. Thank you for allowing me to give you a brief overview of this. This bill 2087 limits the review of certain rules and regs by the Director of the Budget. Under current law, the rules and reg approval process requires state agencies to provide an economic impact statement to the Director of the Budget. And the Director of Budget then considers, in addition to other things, those three things listed in my first paragraph. The Director is also required to make an independent determination regarding implementation and compliance costs and may approve or disapprove of that based on the accuracy of the impact statement or a determination that the implementation and compliance costs would be more than $3 million over 2 years. Additionally, just under current law, for your information, if it's determined such costs would be over $3 million, the agency has to conduct a public hearing on the rule and reg. So what this bill does is it removes the requirement that the Director of the Budget make an independent determination of the amount of implementation and compliance costs and would remove the provisions requiring the Director to approve all rules and regs. Under the bill, the Director would not be required to review and approve rules and regs if the submitting agency determined they would not result in a cost of more than $3 million over 2 years. Agencies would still be required to provide the Director with a copy of the economic impact statement. But the bill specifies that the implementation and compliance costs, and it specifically states would be those costs reasonably expected to be incurred and would be separately identified for the affected businesses, local government units, and members of the public. And that specific amendment, if you're interested, can be found on page 3 in lines 6 through 13. And then additionally, it changes if the state agency is proposing a rule and reg because of a federal mandate, the state agency would still be required to provide an economic impact statement, but the Director wouldn't be required to review or approve those rules and regs, regardless of the estimated costs and implementation. Finally, under the bill, right now, rules and regs are first submitted to the Director of Budget before being submitted to the Secretary of Administration and the Attorney General. And under the provisions of this bill, it would flip, that they would send them to the Secretary of Administration of the AG and then the Director of Budget. The bill would take effect on Charities Register. The House Federal and State Affairs Committee had a small amendment. Right now, under current law, the Division of Post Audit is to conduct an audit to study those three items listed there for you to read. It was scheduled to be done this year in 2021, and the Fed and State Committee moved that to 2023. I might point out to you that LPA has reported to me they have not started this audit, so it would not be an audit in 2021 and 2023. It would just be an audit in 2023, and I'd be pleased to stand for questions.
Thank you, Jill. Questions for Jill? Seeing none, we'll move on to the proponents. First, we'll have Adam Prophet, Director of Budget. Adam, welcome committee.
Thank you, Mr. Chair, members of the committee. Adam Prophet, Director of the Budget for the state of Kansas. Appreciate the opportunity to stand in front of you today as a strong proponent of House Bill 2087. The review of the bill, Jill just did a very nice job of explaining, but basically this bill improves the process as it stands today for implementing rules and regulations. And by improve, I mean it streamlines it a bit and expedites the process and removes a layer of what you might call bureaucracy or a bottleneck in the process. So as Jill mentioned, the current process as it stands today is the agency starts to write their rule and regulation, and then they do an economic impact statement. And that economic impact statement means they review the total cost that that regulation is going to have across the state of Kansas, whether that is on the state coffers or on one of the local communities or the public. So they're reviewing the entire spectrum of the cost. After they do that, they send both the regulation and the EIS, the economic impact statement, to the Division of Budget with their review. My staff takes a look at it. They read the entire regulation. They read the entire economic impact statement, and they do their own independent analysis of the economic impact statement and what they think it might cost. If they have any questions, they'll, of course, go back and forth with the agency and hammer that out, but then they give it to me. When it comes to me, I then read the entire regulation. I read the entire economic impact statement. I read my staff's review of the economic impact statement, and I make sure that it comports with everything that I'm seeing. And then I quite literally rubber stamp it with this rubber stamp right here. And I say it's improved. And I move it on in the process to D of A. D of A then takes a look at it. They look at it for grammatical or technical issues that might be contained on any of the pages. Some of these are one page, one paragraph. Some of these are 30, 40, 50, 60 pages long. Once D of A is done with their review and they also rubber stamp it, it goes on to the AG's office. They review that for any legal challenges. If there are any or aren't any, they stamp that and they move that on in the process. And then it comes to the legislature for their review and approval. I might point out that if any point in the way, if D of A finds a spelling error or a technical error, they kick that back to the agency and say, please correct this on page 3, line 5, you have a misspelled word. They correct that. They send that back to the Division of Budget. We then review that to make sure it's right. We restamp it, we send it back to D of A, then it goes to the AG's office. If the AG sees something that might be wrong, they kick it back to the agency. The agency corrects that, sends it back to us, we restamp it, back to D of A, back to the AG, and then on in the process. I would say, I don't have firm numbers in front of me, but I would say that more than half of the reviews I do are restamps. At that point, we're not reviewing the economic impact statement as closely if it's just a technical error, but it is time out of the day that we're taking to review it, read it, stamp it, move it on the process, and it does kind of slow it down. The new process, as mentioned, would skip me first and would go straight to D of A for their review and then go to AG, and they can hammer out all the technicalities between the agency before it comes to us. We would still get the economic impact statement. The agencies would still be required to look at the totality of the impact across the state. They still have to ascertain whether this just hits the state or if it hits the public or the locals, so that review is still done. It just doesn't come to us for my review unless that threshold is hit of $3 million over 2 years. At that point in time, we would go through a rigorous analysis to make sure that we agree with everything that's in that economic impact statement, and we would stamp that and move that on. Now, I will tell you, we track all of these, and we have to submit a report at the beginning of each legislative session to show what we've done over the past year. And across 2019, calendar year 2019 and calendar year 2020, we reviewed 1,043 regulations, not pages, regulations. Of those 1,043 regulations, 11 had an economic impact of greater than $3 million. So that's 1.1% of the 1,000 that came in there. So regardless of that economic impact being below $3 million, we still had to do the whole review process and go through the stamping and get it across and whatnot. So Under this new process, again, it goes to D of A and AG first, and then if it's over 3 million, it comes to us. So in those 11 instances, we will do the thorough review. We'll have the back and forth, and I've actually had a back and forth with some agencies before where I had some questions on their analysis and what their words were saying, and we got that worked out. So while it is literally a rubber stamp, it's not just a rubber stamp process. We do review it, and we look at it to make sure it's copacetic. So I'll tell you that on my first day of work when I started in this position on December 14th, by 9:30 in the morning, I had been given 3 things: my laptop, my cell phone, and my rubber stamp. My staff was quick to get that to me so that I could take that over so they could kind of stop doing that on their own. With this bill, in all seriousness, I believe it does maintain the fidelity and the original intent of the bill that started this process, which was have the agency review all aspects of cost to make sure that we're not putting undue burden on the state at any level. It still passes a legal review with the AG's office. It still passes a technical review with D of A, and it still passes legislative review with your committees. And with that, I would stand for any questions.
Thank you, Adam. Questions? Senator Fagg.
Thank you, Mr. Chairman. Mr. Director, how did you decide the $3 million number, or where did that come from?
To be completely transparent, that was decided before me. This started under Director Campbell, my predecessor. He worked with Representative Highland on the House side. There was a lot of back and forth on what the number should be, as I understand it. Some wanted 1 million, some wanted 5 or 10 million. I believe it was modeled after a process in Wisconsin, and they went all the way up to 10 million. I wouldn't advocate for 10 million. I think that's too high, quite honestly. But I think 3 million is an appropriate number. I don't know where the genesis was, but I know there was a lot of discussion back and forth.
Director, if we was to change that to $1 million, what kind of effect do you think that would play on this?
I got asked a similar question on the House side. Unfortunately, in the spreadsheet that we track, we don't write what the exact amount was. We just check a box whether it was or was not above the 3 million. I don't anticipate it's going to dramatically increase the number of regs that I would then have to approve under this new process. I will mention there was discussion of that on the House side as well. In some of the conversation, I'm not advocating for one position or another, but the discussion was there was a lot of work that went into this on multiple parties, and they settled on this 3 million number, and they wouldn't want to open a can of worms by changing it to 1 million. What the Senate decides to do is obviously up to you.
Other questions? Senator Solentrup.
Thank you, Mr. Chairman. Who could we get to give us some idea of how many rules and regs this might have impacted prior to this, so we get an idea of how applicable this might be? Is that even remotely available, or would be?
I might ask the revisor's office if that's a number that maybe could be ascertained. Jill, could you answer that?
Ballpark or some global
I
number?
really don't have a ballpark. I am sorry, but we can try to find the answer out for you, sir.
Thank you. That'd be good. Any other questions for Adam? Seeing none, thank you, Adam. Appreciate your testimony today. Next, we'll have Chris Tism, Kansas Department of Wildlife, Parks, and Tourism. Chris, welcome to committee.
Mr. Chairman, members of the committee, I am Chris Thomason, Chief Counsel for the Department of Wildlife, Parks, and Tourism. And I think Director Prophet said everything I need to say. I don't need to follow up too much. I'm more concerned about the structure of how we process regulations and the efficiency. I've been doing regs for 21 years, and I average about 40 a year that go through Adam's shop. And so I want to make sure things are efficient, that those regulations that I deal with generate a significant amount for the economy of the state of Kansas, and it's important that the timeliness of those regulations occurs when we need it. And I think this would improve the process. And with that, I'd be happy to stand for any questions.
Thank you, Chris. Questions? Senator Solentrup.
Thank you again, Mr. Chairman. If I may, looking at this proposal, what kind of impact would it have been over your past tenure on whether it was above or below 3 million, or how it might have affected you?
I have some regs that are above the 3 million threshold, and I probably have most that go through the director's shop. Deer regulations, for example, people pay those fees to hunt, and it's about in the $12 to $13 million range and generates about 400 to 500 million for the state in collateral economic benefit. So that's an example of one. If we changed our pheasant season, for example, that would probably have another impact, depending on how much detail I could get on licenses and what people use those for. So I would say probably I have 10 or 11 regs that maybe meet that threshold out of 180 that we have for the agency.
Other questions for Chris? Seeing none, thank you, Chris.
Thank you.
Committee, I'd point out we also have written only from Katie Copel with the Deputy Assistant Secretary of State Communications and Policies. We also have written only from Tucker Poling, Board of Healing Arts. Are there any opponents here today? Seeing none, we'll move. Oh, yes. We have Representative Ron Highland scheduled, but I think he probably had another. He's on the floor. Ron, are you on WebEx? Not responding. So, committee, I'd point out that he does have written testimony in your packet. So, no opponents. Neutral, we have Randy Stuckey with the Kansas Grain and Feed Association and Kansas Agribusiness Retailers Association and Renewable Kansas Biofuels Association. Randy, welcome committee.
Thank you, Mr. Chairman. I know you've been here a while and we want to get done, but we did want to stand up today and speak on this bill. If you'll recall from 2 years ago, this was initially passed. It was known as the REINS Act, the Regulations of the Executive in Need of Scrutiny. The whole idea behind the bill then was to put an additional step in the place here that required the Budget Director's Office to review the economic impact statement of each set of regulations that are going to be then proposed that goes before JCAR. That wasn't the requirement for the economic impact statement to be submitted was there, but too often what we found was that it was just kind of pencil whipped. There was no economic impact, and I think most of the folks that have served on JCAR will attest to that as well. This new provision, we believe, has been, I think the Budget Director would testify, has been successful in making sure that the agencies, when they go to draft regulations, are now doing a full and complete economic impact statement. And if not, then his office will catch it and send it back to the agency to do an appropriate economic analysis. It's unfortunate, but at the time that the bill was passed in 2018, we did put the Budget Director first before the review of the AG and the Secretary of State's office. And what that did was anytime there was a pencil change, it sent it back through the Budget Director's office through 2 or 3, 4 or 5 times, and he has to stamp it each time. So for that reason alone, we would ask that we would actually be in support of this legislation to juggle the process so that it's now the Budget Director's office at the last review. So he's the last stamp before it goes before the Joint Committee on Rules and Regs. Where we stand in neutral today has to do with the issue that was just asked by Senator Fagg on the $3 million threshold level. Currently, the Budget Director has testified that he has reviewed, I think, thousands of regulations, and his review and approval to make sure that that economic impact statement is fully there, and if not, he'll send it back, has made his office quite busy. This bill would now say that anything under that $3 million threshold, and what we mean by that is a $3 million economic impact on the regulated industry over a 2-year period, that if it's less than that, then he would no longer need to review and approve. It would just have to, the agency would have to submit their economic impact statement, but anything below that $3 million threshold would be set aside. He would no longer need to review and approve. To us, we think that based upon the amount of regulations that have been submitted through this process over that $3 million, which has been de minimis to say the least, really guts the intent of this bill that was passed in 2018. I know that in the bill, there is a proposed legislative post-audit review to see what the necessary threshold should be. Well, I think we already have that information. We know that anything under $3 million or anything over $3 million is fairly de minimis. They're just not there. Even at a $1 million threshold, I think would be more appropriate. The testimony shows that they may be more, but it certainly wouldn't overly tax the process. And so I think we can save the taxpayers' money here and not do that LPA audit because we already have the information. We've been through the process. We've seen the number of regulations that come through. $1 million threshold would be a lot more appropriate, save the intent of the underlying bill, of the underlying REINS Act that was passed a few years ago, and then not to have to do the study. So we would ask for that amendment. We think it's appropriate. We don't need the study, and $1 million threshold seems to be a more appropriate threshold for this process. With that, Mr. Chairman, if we have that amendment, we would certainly stand as a proponent to the bill.
Thank you, Randy. Question, Senator Solentrum.
Thank you, Mr. Chairman. In addition to that, trying to answer that question, Randy, on where that dollar amount should be, perhaps we could look at a 3-year sunset. So whatever amount we do put in there, you and others could see, and we could see the results of this analysis over the next 3 years. And if it needs to be adjusted upward or downward based on its impact, then we could do so.
I think that'd be a great idea. You know, there's always been comment about the Wisconsin $10 million. Well, we're not Wisconsin. For whatever reason, that doesn't even make sense, and it's not reasonable for us. So we want to get to reasonable.
Right. Yeah. We do too. Thank you.
Other questions? Seeing none, thank you, Randy. Next, we'll have written only by Sharia Stafford with Kansas Cooperative Counsel. So it's in your packet. That's written only. Are there any other opponents or neutrals on this bill? Seeing none, we'll close the hearing. Committee, next we'll move on to a hearing on House Bill 2248, increasing the state financial assistance to local health departments under specific circumstances. And first we'll have an overview by research Megan Leopold. Megan, welcome committee.
Thank you, Mr. Chair. Thank you, members of the committee. House Bill 2248 would amend the statutory formula that's currently used to provide state financial assistance to the local health departments. Under current law, state funds are distributed based on population, with each local health department receiving a minimum of $7,000. This bill would raise the minimum amount that's distributed to each of the local health departments from $7,000 to $15,000. It is subject to appropriation, so if the state financial assistance for the fiscal year is $3 million or greater, that raise of the minimum will take place. If the state financial assistance is less than $3 million, the minimum distribution would remain at that $7,000 per local health department. There's currently 2.2 million SGF available for local health departments in fiscal year 2022. So using this formula, so raising the minimum amount from $7,000 to $15,000 is subject to appropriations. But as a reminder, the Senate did recommend adding $1.5 million for state funding for local health departments for fiscal year 2022, which if included in the final appropriations bill, would raise that minimum from $7,000 to $15,000. I'm happy to stand for any questions.
Questions for Megan? Seeing none, thank you, Megan. Next, we'll have the proponents. First up, we'll have Dennis Kreisel, Executive Director, Kansas Association of Local Health Departments on WebEx. Dennis, welcome to committee.
Thank you, Senator, and members of the committee for having me. As was noted, I am Dennis Kreisel. I'm the Executive Director of CALD, the association that represents the local health departments in Kansas. And we are strong proponents for this bill. The state minimum, state formula minimum has been at $7,000 since 1992. That's also been how long we've been at the same allocation amount under the budget, which has been $2.2 million since 1992. And so the reason for wanting to move this up is so that increases in the funding, should we hit that $3 million threshold or above, will actually benefit all of the local health departments and not just those in the more urban counties. Currently, under the allocation that's being planned for in 2022, 68 out of 105 counties only get the minimum. So approximately 2/3 are reliant entirely on the minimum, and updating the minimum is the only way to ensure that they will see an increased benefit, even if we do allocate more money into the formula. And so the way it's done is at the $3 million level, everyone, be they get the minimum or above the minimum, would see an increase versus what they currently get under the $2.2 million allocation. And if less than 3 million is allocated, we keep the current minimum in place so that we do not take money away from urban counties to give to rural counties in order to just update their minimum. So I'd say, as was noted by Megan, this committee approved a $1.5 million increase to that 2.2 million earlier in the session in their budget proposal. You all also supported a $12,000 proviso, temporarily updating the minimum amount from $7,000 to $12,000 for state fiscal year 2022. In a nutshell, this bill removes the need for the proviso. It would permanently address the minimum in statute under 65-242. And this bill in and of itself has no fiscal impact on the state. So that's it. I'll stand for questions at the appropriate time, and I thank you very much.
Thank you, Dennis. Questions for Dennis? Seeing none, thank you. Committee, we have quite a number of written only. Christy Keene, Kansas Department of Health and Environment. Brandon Skidmore, Kansas Public Health Association. Tony Irvin, Grant County Health Department. Diana Park, Trigo County Health Department. Lynn Reddington, Harvey County Health Department. Renee Hively, Flint Hills Community Health Center. Carrie Aldrich, Kiowa County Health Department. Jennifer Keir, Sherman County Health Department. Sheila Shea, McPherson County Health Department. Afton Gardner, Wallace County Health Department. And Tisha Coleman, Lynn County Health Department. Are there any opponents or neutrals on this bill? Seeing none, we will, Senator Hawk.
Thank you, Mr. Chairman. Just a question for staff. When we work this bill, could we find out how much money the local health departments got from the CARES money? I know that there was at least some intention for Spark money to go there, and we did allocate money, $400 million to our counties, and I'd just kind of like to know how much they did get as we look at budgeting here. So thank you, Mr. Chairman.
Good question. And Megan, if you could get that for us, so we'd appreciate it.
Sure.
Thank you. Any other questions or comments? Seeing none, we'll close the hearing on House Bill 2248. And committee, thank you for staying overtime today. Sometimes these go quicker than we think, and sometimes they go longer. So this one went longer. I think we'll wait on working any other bills till hopefully tomorrow we'll get into that.